It's wonderful to be back with everybody, and there's a lot to go over. It seems like every few weeks there are major changes to this program. Thankfully, most of these changes are helpful for those who have a loan and helpful for those who are still interested in borrowing. Let me get to the next slide. Just a disclaimer again that the materials and information provided in this webinar for me, that the NFIB's website are informational purposes only and not for the purpose of providing legal or tax advice. You should always contact your attorney and or tax professional to obtain advice with respect to any particular issues or problems. But the latest change, the Paycheck Protection Program Flexibility Act, was signed into law late Friday, June 5th, and offers a number of flexibilities related to the terms and conditions of the loan program, which is very helpful. It certainly complicates a bit of just trying to keep up with all the changes that have been ongoing through the last 2.5 months that the program was initially rolled out on April 4th. But I think that these flexibility provisions will be very helpful to many of you in using your loan as best fits your business needs and operations. So just to go over the kind of 4 buckets of what this loan or what this law provides, and then we'll go through each one separately in more detail. It lengthened the loan forgiveness period from 8 weeks to 24 weeks, which is incredibly helpful to many, especially those who were not able to get up and running as quickly as they might have wanted and were limited because of stay-at-home orders or other reasons where business operations were slower. And so this gives more time to use those loan dollars and use those loan dollars in forgiveness. And so there's more ability or time frame to have those expenses forgiven. And then the second is that it lowered the amount of the PPP fund that must be spent on payroll. Very helpful for those businesses who weren't able to use all of those dollars on payroll because they didn't have enough, they didn't have their full-time equivalent staffed up already, and so they had more loan dollars available to spend on other things, but were kind of prohibited from doing so in maximizing forgiveness, which is the huge benefit of the loan program, obviously. So they reduced that, and they also allow borrowers to delay their payroll tax payments through the end of 2020. So you can delay your payroll tax payments, and previously you were able to do it up to the time that you applied for forgiveness, but now they've extended it and they've eliminated that restriction, which is helpful. And then they also provided some additional exemptions for those who needed to get their full-time equivalent levels back up to pre-crisis levels. And so there are 2 new exemptions that we'll go over that should be very helpful in allowing small business owners to not have the staff that they did before and not have that reduce their forgiveness total. So we'll start with the 24-week covered period. So the law itself said that you could keep your original 8-week period that was the terms and conditions of the original loan, or extend that to 24 weeks. Which caused a lot of confusion whether it was just 8 weeks or 24 weeks. Secretary Mnuchin testified earlier this morning, and he clarified that you can certainly keep the expenses within the 8 weeks and go with the original terms and agreements, Or you can use the expanded window of forgiveness up to when you are done using your loan. And then at that point, whether it's 9 weeks, 12 weeks, 16 weeks, and then apply for forgiveness right after you've exhausted those funds. So thankfully, it's not 8 weeks or 24 weeks. It's anywhere between 8 and 24 weeks that you can extend the forgiveness window that best suits your business operation needs, and then apply for forgiveness right after that. So borrowers, again, can keep their original 8-week period, or they can extend their forgiveness window up to 24 weeks or until December 31st, 2020. So if your 24 weeks went beyond that, it would be cut off at on December 31st. SBA hopefully will provide more guidance on this. They will certainly have to post a new forgiveness application. That was released a few weeks ago, and there will certainly be amended or adjustments to that based on the new flexibilities allowed in this last piece of legislation. And then hopefully they will, document some of the clarifications and instructions on the forgiveness window. We did hear Secretary Mnuchin say that this morning in testimony, but hopefully that is translated into a document that will soon be posted by SBA and Treasury to offer more clarification on some of these provisions. And again, we assumed I added this bullet before we knew from testimony earlier today, but we had assumed that borrowers would be able to choose their own kind of covered period end date, that they wouldn't have to wait. Because obviously for many small business owners, and golf courses, when you use the loan amount as prescribed, then many would have to readjust their workforces after they've used the loan, and many were worried that they would have to keep those FTE levels up for the whole 24-week period, but you don't. So once you apply for forgiveness or once you've used your loan amount, then you can readjust your business operations accordingly if you have to without the support of the loan itself. And then the next provision or the next big flexibility that was offered in this law was that the 75 payroll rule is now the 60% payroll rule. So before you had to use at least 75% or more of your forgiveness expenses on payroll, but now it's at least 60% have to be used on payroll, and then up to 40% can be used on other qualifying expenses. So just to go through briefly what this looks like, again, the payroll category includes salaries, wages, commissions, and tips. They're capped at $15,385 per employee for the covered period. That was based on prorated $100,000 for 8 weeks. I don't know whether they'll change that. Say you have more dollars for your loan than you and fewer people than you had before, those dollars would stretch out longer. So, we don't know that if you use the loan to pay somebody beyond 8 weeks and that then exceeded the $15,385 cap, if you'll be allowed to do that, or if they're going to keep intact that cap. We're not sure yet. That's still one of the outstanding questions that we have. But right now it's capped at $15,385, which is prorated the $100,000 cap for 8 weeks. You can use the loan. This was one of the forgiveness guidances that was posted by SBA a week and a half ago, 2 weeks ago, I believe, that you can use the loan dollars and include it in payroll for hazard pay or bonus pay. So if you have loan dollars left over, This was more important when it was confined to 8 weeks. If you weren't able to use all those loan dollars, you could then give your employees bonuses to use up the rest of the loan. But now that you're able to use it for a longer period of time, essentially likely wouldn't have to then use up these loan dollars with hazard pay or bonuses. But if that is helpful in getting folks back into those positions, if you had to lay them off, and you can use bonuses or hazard pay to help fill those positions, then you are able to do that. SBA has said that that is permissible use of the loan for payroll. Also, owner replacement compensation. So there are owners that are employees, and then there are owners who are that either took a draw, which you can't include in payroll, but you can use owner compensation replacement for those who filed a Schedule C or a Schedule K1 or a Schedule F, although that doesn't apply here. Those would be for farmers. But for Schedule C, you're looking at the net profits, and you can pay yourself back in owner compensation replacement if you are not a owner employee 8 weeks out of 52 weeks of your 2019 net profit. So that would be line 31, and you would divide that by 52 weeks and multiply that by 8, and that's what you can pay yourself back. And that's also included in payroll. So the up to, or the at least 60% or more category, you can include that in payroll. And then if you're a partner, then you're looking at the Schedule K1, same calculation. You're looking at net profits there, 2019 net profits, and then you're multiplying or dividing that by 52, multiplying it by 8, and that's what you can pay yourself as a non-owner employee. Limited to 8 weeks, so you can't pay yourself any more than that. That was in SBA guidance if you're a W-2 or for the replacement calculation, and that is not likely to change as far as these new flexibilities. So likely that will remain the same, 8 weeks. Group health insurance premiums and retirement plans. Those are included, those costs that are paid by the employer to employee benefits, those costs are included in payroll. If you are an owner, W-2 or owner employee with a W-2, you can include and pay for your health insurance plan costs and retirement costs that the company is paying for you. However, if you are not a W-2 owner employee, you cannot use the loan to pay for your health insurance or retirement benefits. So only owner employees can have those costs paid for by the loan. That is one of the kind of catches in this, that it only is towards employees and also owner employees, but not for owners who are not W-2s. And then up to 40% on non-payroll expenses. And just to go over this briefly, because there is a bit more information that was released in the forgiveness application itself, but also in the guidance that was posted by SBA. So now up to 40% can be used for these non-payroll eligible expenses, and those include rent, and that includes on real and personal property. So not just the building or anything else that you're renting that is the immovable object, but if you have leases on equipment or anything like that, personal property is also an eligible expense as far as rent. The lease for these, for the real or personal property had to have been established by February 15th. For all of the non-payroll expenses, they all have to have been in place by February 15th. So the lease had to have been executed. We've had a few questions about, well, whether, if we had a lease and then we have a new lease and it was after February 15th, can that be included? And as far as we can tell, no. So if you had something that was a new lease after February 15th, and even if it was kind of in the same lease as before, but if it's new, it won't qualify as an eligible expense. So it had to have been in place by February 15th. So just a little bit of clarification there. Utilities, services in place before February 15th include electricity, gas, water, internet, so that would be internet service, telephone. Telephone includes, as we understand it, landlines and cell phone service. So not the cell phone itself or the phone itself, if you have a sophisticated landline system, not the equipment, only the service as far as we understand it. And then transportation, as we understand it, it's covering fuel for business vehicles, but we don't know what else it includes, and they haven't given any more information about what might be in that bucket. We've received a number of questions related to transportation, what's included. We think that that's the basic definition of what we think might be included is fuel, but other than that, we don't know. And then the other kind of utility that we keep getting asked is trash, and it's not listed in here. So I would say that it's not an eligible expense, even though it seems very logical that it would be part of this list. But right now, talk to your lender to see if they think it would be part of these eligible expenses. But right now, it does not appear so that trash would not be included as an eligible expense. And then there's mortgage interest payments on real and personal property. So both rent and mortgage interest payments include both real and personal property. And it's if the mortgage has been executed before February 15th again, and it's just on interest payment, not on the principal of the mortgage. So for utilities payments, we've received a lot of questions at NFIB about, can you include a payment that you're paying within the covered period, but if you have a loan that started, say, June 1st, and you normally pay May's expenses June 5th, is that an eligible expense? So in the SBA's forgiveness interim final rule, it is an eligible expense. So if you normally pay something within the covered period, it is eligible even though the service was accrued before the covered period. And so you can include that. You would be able to include May's expenses if you normally pay it within the covered period of June. That's permissible now. And so we did have some clarification on that. Here's the example that's in the interim rule. I won't go over it, but it's here in case you have questions afterwards. But it is those expenses paid or incurred during the covered period and or incurred. So you can have expenses that you paid, expenses that are incurred, and you have both payments or all payments in those two situations eligible for forgiveness. And then exempt employees for the FTEE calculation. This is a huge flexibility for many small business owners. The amount of loan forgiveness will be determined without regard, so won't be reduced, if the number of FTEEs, that full-time equivalent employee calculation, so that's based on the 40 hours a week or more is considered a full-time employee. So you would give them, they're allowing for a simpler way of calculating. So the simple way is if you have employees that are 40 or more hours per week, they are considered a 1. Anybody who works less than 40 hours a week is considered 0.5. And so, it doesn't, if you consider 35 hours a week full time, as far as the calculation goes, it really doesn't matter because, it's apples to apples how you're calculating the FTEEs in the covered period and how you're calculating it in the look back period. So if you're calculating if you're determining that, or, for your purposes, if say 35 hours per week is full time, you would still consider that 0.5 as you would consider that a 0.5 in the look back. And they're just making sure that those levels are the same pre-crisis as in your covered period. However, again, they've offered some flexibility with this number, with this requirement for maximizing loan forgiveness. And so one is, if you are able to document the inability to rehire individuals who were employees of the firm on February 15th and can't hire similar qualified employees for unfilled position on or before December 31st. So basically, if you have an unfilled position that you can't find qualified applicants to fill, then your maximum forgiveness amount will not be reduced if you can't fill that position. So you just need to document it and make sure that you're adding that to your list of paperwork for your lender. But if you're unable to fill a position with anybody who, necessary qualifications, that will not go against you as far as forgiveness. Also, and likely more importantly for many, is you won't have your maximum loan forgiveness reduced if your FTEEs are not up to pre-crisis levels, if you can document the inability to return at the same level of business activity as your business was operating before February 15th due to compliance with requirements or guidance established by HHS, CDC, or OSHA during the period of March 1st through December 31st. So all of those state stay-at-home requirements, the non-essential business shutdowns, the limited business operation requirements that are imposed by the states, all those state executive orders are coming from guidance from the CDC, HHS, and OSHA. So it was a little confusing because everybody was thinking, well, there's this disconnect. How do I know which regulations or guidances are CDC versus my specific state? The states are all gauging their, executive orders related to business operation limitations and stay-at-home orders on the recommendations and requirements of CDC, OSHA, and HHS. So they're all connected. So if you're impacted by stay-at-home orders or limited business operations or non-essential, if there are parts of your business that were deemed unessential and you can't open them back up fully, then this would apply to you. And if you are in this kind of clause, if this is reflective of your situation, then you don't have to increase your FTEEs to pre-crisis levels. This is an exemption, and you won't be reduced for forgiveness totals. This will not count against you. So this was huge. And then they also did repayment period. They lengthened the repayment period on new applications. So for those who haven't, have applied for a PPP loan after June 5th, their loan term, if they have any dollars left over that they're not applying for forgiveness, if they're using any of those dollars as a 1% loan, you have a repayment period that's been extended to 5 years. So the repayment period has been extended from 2 to 5 years. If you already have a loan and you are interested in using some of those dollars as a loan, you would have to go back to your lender and ask to extend that term period from 2 to 5 years. It won't automatically be extended. You'll have to go back to your lender and negotiate that with them. And, you know, it's up to the lender whether they will allow that for each borrower. So, you know, they might not, they might, you know, if this is of interest to you and you already have a loan, you know, just ask your lender if there's a way to extend that time frame from 2 years to 5 years. But that's the new term for new PPP loan borrowers. And then the interest rate at 1% has stayed the same. There was no change in that. And then so you can delay your employer payroll tax payments through the end of the year now. Before, you could delay payroll tax payments for Social Security taxes under the CARE Act up until you applied for forgiveness, and then the deferment, you couldn't defer anymore. But now they've lifted that restriction so that all employers who receive a PPP loan forgiveness can continue to defer payments of the employer's share of Social Security taxes under the CARES Act through December 31st. And again, the original PPP restriction was that you could defer these payments up until loan was forgiven, and then deferment ended. But this extends it for everybody who has a PPP loan through the end of the year. And then some other important changes, you have to apply for forgiveness within 10 months of your end covered period. So failure to apply for loan forgiveness within 10 months at the end of your covered period, so when you've used the loan, all right, actually in this case, because it would be the 24 period, they would consider that your whole entire covered period, the 24 weeks. After that, you would have 10 months to apply for forgiveness, and if you don't apply for forgiveness within 10 months after that 24 weeks, then they're going to require you to start paying it back as a loan. So once you're done with the loan, apply for forgiveness and you won't have to worry about this. The loan payment deferral period has been extended from 6 months to the time when the SBA has compensated the lender for the forgiven amounts, which they thought may exceed 6 months. So it's either 6 months if somehow SBA compensates the lender before then, or if it's after the 6 months, then it's extended to when the SBA compensates the lender for the forgiveness amounts. So there's a little bit of flexibility on that also. But for most, for most borrowers, obviously the attractive part of this loan was the forgiveness element of it. And with 24 weeks to use those loan dollars on eligible expenses, hopefully most, if not all borrowers can take advantage of that lengthened forgiveness period and not have to turn any of the loan dollars into a loan. But that is available to borrowers. And then just one last note that there is still money in the PPP loan fund that was allocated to the program. There's still, I believe, about $120 billion left out of the $660 billion allocated. And you have up until June 30th to apply for a loan. So if you are still interested or know somebody who's still interested in applying for a loan, whether they are an employer or somebody who's self-employed, there's still a few weeks left to apply for the loan. The Flexibility Act did not extend the application deadline. So it only extended the forgiveness period. The application deadline is still June 30th. I don't know what they're going to do. Maybe they'll, extend this at some point. But right now, the last day to apply for a PPP loan is June 30th, but there's still money and there are still loan applications. Two that we know about who are still accepting loan applications are PayPal and Cabbage. And also you can find available lenders for PPP loans through the SBA website, which I've linked here. But first and foremost, go to your bank and ask them if they're still accepting applications. Many banks are. Some have reached their limit on how many loans that they can, or loan dollars that they can loan out, so that they've hit their limit threshold. But ask your bank, and if they are not accepting, PayPal and Cabbage are still accepting, and also you can find other available lenders through the SBA loan site. And then we do have some other resources on the NFIB website. There are links here if you're interested. And then links to the forgiveness application, which, as I mentioned, will be amended. So that will change in the next week or so for those who are extending outside of their 8-week period. It will change for everybody because of some of the additional flexibilities with the FTEEs. But if you're interested in taking a look at the application, it is available here just to get a sense of what might be required. And then as far as unemployment information, we've received a lot of questions from NFIB members about where to look for unemployment information for, the Department of Labor website has a great list of resources and information about state unemployment programs. And with that, I have 2 questions that I received earlier. So I'll start with these 2 and then open it up to other questions that you might have. But the first question was in regard to the wages forgiveness penalty. If an employee who has not been terminated works 0 hours during the covered period due to not being needed, would there be wage forgiveness penalty for this person? There appears to be no penalty for an employee who works just 1 hour during the covered period and is paid an hourly rate equal to his 2020 average hourly rate. So, yes, correct. The wage reduction is only based on hourly rates. So if you are, if somebody, for instance, as an example, if say Amy was making $20 an hour, you could reduce Amy's wages to $15 an hour, and that would be the limit, 75%. She still needs to make 75% of her wage rate before forgiveness reduction kicks in. So you can reduce it to 25% without impacting your reduction in forgiveness. And so the salary requirement is just on the rate of pay, not the full amount. What gets to the full amount is the FTEE requirements. So if you aren't exempt through all of the other kind of provisions, the FTE, when you look at having the simplified form of, one employee that works over 40 hours or more, you would have them as one employee. You need those levels to be back up at pre-crisis levels, or you will experience a reduction in forgiveness. So while there is the rate, there is also the FTEE requirement if the exemptions don't apply to you. The second question is with regard to the FTEE forgiveness penalty and its safe harbor exemption. What does getting the December 31st FTE count equal to or greater than the February 15 count actually mean? Having an FTE count on the payroll date that includes December 31st to be equal or greater than just February 15th count, having an FTE count for a set of periods before and including December 31st, then February 15th count. How do you navigate that? So it's a lot of windows. It's looking at, the safe harbor is looking at, how many employees did you have pre-February or February 15th or before? And if you reduced the number of employees from February 15th to April 26th, and April 26th is kind of this arbitrary date, but that's what's in the law. So if you reduce from February 15th to April 26th, if you reduce the number of employees in that window, you need to increase employment during your covered period. So if you keep the 8-week period, it would be within that 8-week period. If you extend it to the 24-week period, it would be however long you're using your loan. But you would have to get those FTEs back up to that February 15th level. However, with the exceptions that were allowed for in the Flexibility Act, those exemptions will likely apply and will kind of negate all of the safe harbor parts of it, because if you're not back up to full employment as you were before in your look back period, or if you are in that safe harbor calculation, if your business operations were reduced or declined because of the COVID-19 kind of state orders, then this is all pretty much irrelevant, because your loan forgiveness won't be reduced if you're not increasing employment because of that. So if business operations have declined because of COVID-19 related requirements of your state, then you don't need to increase your FTEs to pre-crisis levels. Your forgiveness won't be reduced under those conditions. So that was one of the huge forgiveness FTE flexibilities that were allowed in this latest piece of legislation that just passed on June 5th. So with that, I will go to questions that have come in. Let's see. But I can't see them.
Holly, would you like me to read these off for you?
Yes, that would be helpful. I am having a hard time with technology right here, right now.
The first one from Sue Chamberlain is, when calculating FTEE counts, you mentioned covered period and look back period. What is the covered period referring to?
So the covered period is from the time you received the loan through either the 8 weeks, the original terms of the program. So if you're still using your loan dollars within the 8 weeks, the covered period would be when you received the loan and 8 weeks going forward, 56 days. Or if you're extending it beyond 8 weeks, it then is whenever basically you decide when your covered period ends. So when looking at the FTE counts, when you apply for forgiveness, when you've used up all of your loan dollars, that would be essentially your covered period. Or you can have the covered period last the whole 24 weeks.
Okay, good. The next one again from Sue Chamberlain. Just to clarify, we now have 24 weeks to not only use the loan dollars, but also to bring the FTE counts up to the pre-COVID levels.
Yes, so you have up to 24 weeks. So you obviously don't need to hold on to, FTE levels that hold 24 weeks. If it takes you that long to get up to those levels, if you don't qualify for these new exemptions, or not covered by these new exemptions, then you do have 24 weeks to get those levels back up. Or you can get those levels back up from when you receive the loan up until when you basically apply for forgiveness. And that would be, kind of your covered period. And then you could readjust business operations or your workforce levels after that. So you don't have to keep your workforce levels up the whole entire 24 weeks. But you do have 24 weeks to do that. Hopefully I didn't completely complicate that.
That's good. Excuse me. Can we choose whatever period we desire within the 24 weeks to report the payroll money spent, and whatever period we desire within the 24 weeks to report the non-payroll money spent? Or do we have to submit information for the entire 24 weeks, even though the amount spent over 24 weeks may be significantly higher than our loan amount?
Yes, so good question. So you have, the documentation would be from when you receive the loan to then when you apply for forgiveness, and that would be your covered period. So whenever you've exhausted all your loan funds, or when you've decided that the forgiveness amount that you want to apply for ends, that is your covered period, and that is the documentation that you would need to maintain for up to 6 years. And in the forgiveness application, it lists all the documentation that you need to keep and some of the documentation that you would need to provide your lender. So that would be, you know, you're kind of self-determining the end date of your forgiveness window is when you basically apply for forgiveness. And then after that, you can use those dollars as a loan on qualifying expenses. So you can use those dollars as a loan, a 1% loan. In the Treasury guidance, the FAQs, they basically say that, you know, you still need to use those dollars up to 60% of forgiveness. This is one of those, I don't think I mentioned this. If you don't use up to if you don't use at least 60% of the loan dollars on payroll, say you use 50% on payroll, that it's not a cliff. So you will still have forgivable expenses that qualify. It will just be reduced proportionately. So you know, you can determine when the end date is for your forgiveness period, and then, you know, you can use the rest of the money for, you know, as a loan. But I just wanted to clarify that it's, you know, at least 60% on payroll. If you don't meet that within the covered period that you've designated, your forgiveness amount will be reduced. It won't be disqualifying altogether.
So just to clarify, the 40% other expenses would be relative to the really the difference or the percentage of reduction at the same level of reduction as the labor was.
Yes, so if you, so say you used the loan and within your kind of designated forgiveness window, and you used 50% on payroll and 50% on other expenses, it would just be, you wouldn't get the maximum amount of forgiveness would qualify. It would be reduced a bit from that, but you could do that if you wanted.
Okay, the next question, have you heard anything regarding the cost of sanitizing our property, et cetera, as to this expense being deductible?
I don't know that. I know that that is not a qualifying expense for PPP loan money. I don't know about, I don't know how it relates as far as a tax deduction. I don't know. I want to say that it is, but I'm not sure. So I can, that one actually, I know a coworker who will likely know the answer to that. And so I can get back to Ronnie.
Okay. The last one right now we have is for owner employees, given the new guidance, do they still use the current formula, Schedule C, line 31, divided by the 52 times 8 equals in determining how much to pay oneself? Or does the new guidance say that the owner employee can pay the entire loan amount to oneself?
So an owner employee, if you paid yourself a W-2 in 2019, then it's the W-2, but you can only take out 8 weeks of that and use that in paying yourself with the loan. If you're an owner not employee, so you don't have a W-2, then you're using that Schedule C, line 31 net profits, and it is still just 8 weeks out of 52 that you can pay yourself and no more. And then the rest of the loan you can use on other expenses, other qualifying expenses.
Okay, good. Another one coming in. Am I understanding it correctly that that there is a wage penalty for an employee who is paid for 0 hours during the covered period, but there is not a wage penalty for an employee who is paid for 1 hour during the covered period at their base period average hourly rate?
Yeah, so as far as I know, it's a kind of a weird way of having this be calculated, but basically, yes, it is just the wage rate. So it is, you know, that position, you pay them for 1 hour at the wage rate that they were paid before, then that satisfies that condition. However, if that person is considered a 0.5 because they are, you know, their hours have been reduced and they were considered a 1 before, then that will reduce your loan forgiveness total. So there's the wage and then there's the, you know, hours worked. But the wage rate, yes, theoretically, yeah, as you fill out the form, if they work, you know, reduced hours, even 1 hour, but paid the wage rate as the same as they were before, that would satisfy that condition.
Good. Okay, that was the last question we have for today. Holly, I want to thank you so much again for joining us and helping us navigate through this very complex program, the PPP. So I don't have any more questions coming in, but again, we thank you and I hope everyone has a great week.
Wonderful, thank you.